Guys, well, we will go ahead and get started this morning. I know this was kind of a last minute announcement at the end of last week, but that's kind of the world we live in right now. And Mr. Bill Rochelle is joining me in my office because it wouldn't be a Monday morning without one of us having some technology difficulties. So, but want to thank Mr. Greg Northen for being willing to share his insight this morning. Probably most of you have heard a spiel from Greg more than once through ABC. He's wonderful about sharing his resources and knowledge with us, and he is kind of on the forefront of all this mandate craziness as much as anyone can be in this type of situation. So Greg, I'm going to let you take it over. And guys, Mr. Greg Northen with Gunter, Witherspoon Galchus. I do want to remind everyone that this is being recorded, so we will try to send a version of this out after the meeting. So if you don't get to stay for the whole thing, we will have another avenue for you to hear this information. But without further ado, Greg, I'll let you take it away, sir.
Good morning. Thank you, Megan. Appreciate the opportunity to share my knowledge, although you might want to hold off on thanking me until the end, because as you'll see, I'm going to probably have a lot of, I just don't know the answer to that question right now, because this stuff is like nailing JLO to a wall. We have had a tumultuous few months here on the compliance side. And, speaking with Bill after the big announcements last week from the Supreme Court, we thought it might be good just to have a quick check-in, this is designed, I think, 30 to 45 minutes at most. We want to get y'all back to work, but answer what questions we can right now. So I'm going to be fairly brief on my review. I will take questions. I encourage questions. Please interrupt me. This is much more enjoyable. This is supposed to be a discussion style, webinar. But since it's being recorded, I may answer some later after the session ended. And some of y'all emailed me last time. Feel free to do that also. I try to get back to those ASAP while it's still fresh. So without further ado, I don't have any slides today. We're just going to talk. Let me give you a quick recap of where exactly we are. Back in September, President Biden signed 2 executive orders. One was to authorize OSHA to enact a new rule for safety workplace through vaccine mandates. The other was for federal contractors under 14042. We're going to talk about Executive Order 14042 today. That's our primary discussion. As most of or all of you know, OSHA rule got killed last week. But just for a quick recap of where we are, where we've been. The OSHA rule was announced in early November. It has been tied up in litigation. The Fifth Circuit stated, then the Sixth Circuit unstated, then it went to the Supreme Court. And last Thursday, the Supreme Court has basically said this thing's dead. 6-3 ruling. It is still technically processing back down the way an appeal to the Supreme Court works. This was an interlocutory appeal, so it wasn't a final adjudication on the merits, which means that the courts have to process it back down all the way to OSHA. But for all indications that we've seen, OSHA's not going to try to revive it. It's basically a death nail, although it still technically is out there pending final adjudication. So maybe another 30, 60 days until the rule is actually dead. But you do not have to comply with any OSHA mandate. And that's huge. Okay, that was a big, you can call it a win or a decision, whatever you want to call it, for employers who didn't want to have to be subjected to the testing, because the OSHA rule, it was designed to be a vaccine mandate or weekly negative COVID testing. And that was great for people who didn't want to mandate the vaccine, but it was not great for, mid to size scale contractors who don't have huge HR departments or operational folks who can organize weekly tests for your offsite, your workers. That was going to be a big difficult, and there were issues with costs, paid time. You have to pay somebody to get their test every week. So we had a lot of legal issues there. That is all done. So going back and focusing on the federal contractor executive order, which is 14042, that was designed and announced where President Biden, through his authority as the chief of the executive branch, instructed all executive agencies to issue rules implementing the guidance from the SAFER task force. I don't know if y'all have heard about that. That's just the White House's think tank for vaccines and COVID. So the Safer Task Force put out their overall guidance on what they wanted to accomplish. And then each federal agency was tasked with implementing its own set of rules. And so to date, we've seen basically 3 sets of those. The Department of Defense, I believe, has issued theirs. CMS is the Center for Medicaid and Medicare Services. We're going to talk about that one primarily. Then there's also one through the Department of Education, which doesn't apply to most of us, although if you're doing work on schools, it's going to apply to you also. There's also a subset of rules through the Head Start agency. That is stayed, but the CMS rule is not stayed. This is kind of confusing, okay, without going into the legal mumbo jumbo. Remember, there was the OSHA ETS executive order, and then there was the federal contractor. All of this is under the cone or the umbrella of federal contractor, right? And so each agency, so if you do business with any agency, they're supposed to have rules outlined and contract amendments to flow down from the responsible agency. The contracting officer for each federal agency was tasked with implementing the rules to all of the contracts, the prime contractors on those projects, covered contracts, and then the prime flows it down to the sub, first sub, second sub, all the way down. That's how it was designed to work. It's been in flux because the CMS rule was stayed back in December, actually I think late November. And so it's been stayed until last Thursday when the Supreme Court said, no, the CMS rule can go forward. Head Start is still stayed. It's its own lawsuit. It's out in Arizona. The CMS rule has been in Georgia. So the CMS stay has been lifted. On Friday of last week, the CMS office issued a new update for the 24 states where the stay had been in effect. So all the states that had been on pause pending the Georgia ruling have now been given extra time, and that's good. You can go online and find it. It's called the, where is it? Well, I don't know the name of it, but I'm looking at it right here. Oh, here it is. It's called the Guidance for the Interim Final Rule Medicare and Medicaid Programs Omnibus COVID-19 Healthcare Staff Vaccination. Boy, ain't that a mouthful. I'll email this to Megan. If anybody needs a copy, you can request it from Megan. It's just a 5-page PDF, and it basically is a recap of exactly what the CMS rule says and the new deadlines. They to the government's credit, they did push out the deadline for the states where it's been enforced, because as of now, you had to have your first vaccines this month, January. That's now been pushed back to where if you're a covered contractor, and we're going to get into that in just a second, well, you have 30 days to implement your policies and your first shot. You have 60 days to get 100% vaccination or 100% accommodation. And then 90 days, the state surveyors for CMS offices are going to be enforcing this. So that's kind of your timeline for those of y'all who jumped on here just wondering when you have to. If you already know what you have to do, then your new timeline is basically outlined in that new CMS bulletin that you can get from Megan. So I'm going to do my best to put this in just kind of general terms. This is very complicated legally, and I don't want to go into the details, so don't ask. And if you want to talk to me afterwards, I'll bore you to death. But what CMS has implemented is a rule that applies to all covered. If you have a certificate of participation in any covered CMS program, then you are covered. That is typically, this is the list that the rule specifically includes: hospitals, ambulatory surgery centers, dialysis facilities, home health agencies, clinics, rehab agencies, public agencies, providers of outpatient physical therapy, speech language, psychiatric residential treatment facilities, long-term care facilities, including nursing homes and others, programs of all-inclusive care for the elderly, home infusion therapy suppliers, rural health clinics, and end-stage renal disease facilities. Okay, so that's your bulk of your CMS certificates of participation. Now, other agencies who provide these services, so for instance, I have several clients who do some home health care work, and if they're on a covered contract through an assignment or their own contract, they can be pulled into the CMS rule by providing these types of services. So the CMS rule generally provides a mandate for a vaccine, COVID-19 vaccine, for all persons. It's kind of weird. There's facility coverage, which is what I just described to you, and then there's individual coverage. So none of us on here are going to be facility coverage. We're not, I don't think, unless, Kinko or Kuntz or somebody's NAPulse is opened a end-stage renal disease facility I didn't know about. I don't think we're going to be covered. So assuming we're all just construction contractors, which I think is safe, we're going to only be worried about the individual coverage, right? And this is where the legal analysis gets a little bit wonky. It's because the rule is in effect. It's almost like a new law, and it applies to the facilities that are covered. The law also applies, it defines coverage for the individuals who are not employees of the covered facility. So here's the most prevalent example: a doctor. Most doctors are not employees of hospitals. They're independent agents, they have admission privileges, they have contracts to work at the ER, they do clinic visits, they see patients. Most doctors are contractors, either of their own healthcare clinic with hospitals or through the hospital, a solo proprietor, however you want to do it. Some are employees of the hospital, but a lot aren't. So if a doctor is going into a covered facility and seeing patients, then she is going to be covered by the CMS rule, even though they don't have a contract with the federal government, right? They do their work through the hospital. The hospital has a contract with CMS that receives the funds. So the money is followed from CMS to the hospital, or whether as the prime or sub or whatever, typically a direct contract. And then the hospital has to implement policies and procedures to cover the doctor. It's the same for pharmacists. There's a lot of pharmacists and lab technicians. If they have employees of an independent pharmacy or an independent lab, but they are coming into the hospital regularly to pick up blood samples, biological samples, get rid of waste, give medicines, whatever it might be, biopsy samples, and then take it back to the lab. If they're coming into a covered facility, then they're also covered by the CMS rule. And so the hospital has to have a rule in place to implement a vaccine mandate for those persons. The rule is so broad as written, and remind you, this is just an interim final rule is all we have. We don't have a lot of other authority. That's why I'm saying some of this stuff is me doing my best right now. But within the next 30 to 60 days, if you're a construction company and you're under a current or a future project with a covered facility, then the individual employees that you send to that work site, whether it's a VA hospital, a nursing home, rural health clinic, whatever it is, if they're on site and mingled around other covered employees of the facility or patients, then they also fall under the vaccine mandate. Now, where this gets tricky is just like the doctor, you may not have a contract. You as a construction company, you're not going to have a contract with CMS directly, right? There's no privity. There's no direct privity of contract with CMS. Your rights and your obligations and your money comes through a contract with the facility. You're going to have a construction contract. The CMS rules are supposed to be implemented through the covered facility to all workers, but those are not the employer of your employees. You are. So as the employer, this is where it gets real tricky. You're going to have a contractual requirement to mandate a vaccine for any workers who go onto the job site of a covered facility. So you have to do the analysis as to whether those employees who would otherwise be assigned there or decide first and foremost, are they vaccinated? If they're not, mandate the vaccine. By the way, the CMS rule, I haven't made this clear, but if you don't know, the CMS rule does not have a negative weekly testing alternative like the OSHA rule did. So it's just a vaccine mandate. That's it. With that, the ADA and Title VII accommodations, so if you have a disability or a religious belief that interferes with your ability to get the vaccine, then you can request an accommodation. So your employees are going to request, if they're going to request an accommodation, are going to submit that to you, the employer, so that they can work on site for your client, the covered medical, the CMS facility. You have to accept, analyze, and approve or reject the accommodation requirements. And this is where it gets, I'm not really sure where we're going yet. We'll see in time, but our understanding as of right now is that those covered facilities, let's say you have 7 people on a crew that you're going to send to a rural health clinic to do a remodel and expansion or whatever. And out of that 7, 3 are unvaccinated. All 3 request disability or religious accommodations, and you're not really too concerned about it. So you just say, yeah, sure, we'll approve those. That looks good. Sincerely held religious belief, we're not going to trample on your rights. Granted. The CMS facility, from what we understand, they can still exclude any person who remains unvaccinated from coming onto their work site. This is where the legal wires are. We have exposed wires all over the place legally. Let me put that in contractor terms, because the CMS facility doesn't owe an ADA or Title VII accommodation right to your employees. It's all contractual, right? But you do. But then if they're asking you to violate those rights, is there any recourse that the employees have against you or their covered facility? Right now in this environment, we're going to say probably no, but there is a legal theory where they could try to challenge that. Okay, I'm putting that out there to cover my bases, knowing this is a recording, that you may have an issue. So as a construction employer, you're going to need to determine if you have an employee who's unvaccinated, which I'm sure several of you all do from my discussions. You know, if you haven't mandated a vaccine by now, you probably don't want to. And not to mention, last week on Thursday, the Arkansas statute went into effect that requires Arkansas employers to provide an alternative to any vaccine mandate by a private business through weekly testing or proof of a natural immunity through having COVID recently or otherwise. If you're covered by CMS, though, it specifically preempts that Arkansas statute. So if you're a CMS covered contractor, for those employees, you cannot provide an alternative weekly negative test. That is not accepted by CMS. And look, you're sitting here saying, well, Arkansas law is telling me this, federal law is telling me that. It's the preemption doctrine. Federal law and state law, whenever they conflict, federal law wins as long as it's lawful. And we just found out last Thursday the CMS rule is lawful. But for any of your other employees, if they're subject to a vaccine mandate from a client, maybe you have other clients who just will only want, and I've had this conversation with a few contractors, your project owner, the owner of the building or the general manager of a facility is implementing their own private vaccine policy that's mandated for all persons working on the job site. If that's not through CMS, then by Arkansas law, you do have to provide weekly negative testing as an alternative. Now, that's between you and the owner or whoever's trying to force this vaccine mandate on you, and it may or may not apply in other states too. So that gets real dicey when you're an Arkansas employer and you have employees working out of state. Do you have to provide that? I'm not going to answer that on a recording. So it's just another layer of the onion that we're having to deal with right now. But if you're a CMS covered contractor, you're putting workers who are sharing space, if they go into a break room, if they're walking the halls, if they're on site in any way coming into contact or potential contact with the covered employees of a CMS facility, then those persons are going to be subject to the CMS vaccine mandate. And so what that means is within 30 days from the 14th, so February 13th, they must have at least their first vaccination. You must have a policy in place. And look, if you're doing work on CMS projects, I would encourage you to have a policy in place right now, irrespective of whether you're going to actually mandate the shot. Just have the policy in place that says, depending upon weather coverage on a case-by-case basis, the chief operations officer will let you know, something like that, so that if you come in and get audited, because here's what's going to happen. After 90 days, the CMS state surveyors, who are the enforcement arm of CMS, and look, CMS doles out billions of dollars every year. Those surveyors are going to start auditing their money recipients, CMS facilities. And if those auditors find that they're allowing unvaccinated persons to come onto their site during the CMS rule, then they're going to be fined and possibly lose out on future CMS funding. No facility that I know of can jeopardize receiving their CMS funding in the short term. I mean, maybe a few who just dole on the side of some CMS funds, but most CMS facilities, their primary income is through CMS covered funds. So it's going to be very difficult for those entities to not comply with this vaccine mandate and run the risk of, well, what's the problem? What if I don't want to agree with this? Now, that said, for those of you who saw Arkansas Business this morning, like I did, just scrolling through and I haven't read it yet, I'm real intrigued to see how this is going to work. Apparently, Florida as a whole, which I don't think works, but Florida is refusing to follow the CMS vaccine mandate. What I take that to mean is a few hospital groups have said we're not gonna comply, and they run the risk of losing their CMS funding. And probably Governor DeSantis will come in with some emergency money to prop them up, and it's that's a big political thing. And you may be thinking, well, I want to do that here, and that's for another webinar. But I guess any entity can reject. The vaccine mandate comes from the funds from the federal government. And so the authority behind the rule, the United States Supreme Court has said the CMS rule is authorized because the executive branch can distribute funds with whatever reasonable strings that it wants attached. And if you're doing federal work, you already know this. I mean, how many federal contract addendums do you have? How many extra contract clauses are thrown in there for, EEO and diversity hiring, disadvantaged business enterprises, environmental requirements, all these extra things the government wants to see you doing in order to do business with the federal government. That's why this is coming through. So anyone can refuse those funds, and you can turn down a future project. But if you're going to receive the funds that come through a CMS facility, at least in the next 90 days, then you're going to have to comply with this policy, which, again, just to recap, you have to have a policy in place. You have to come up with a list of which employees you have that are vaccinated and which aren't. For purposes of this CMS interim final rule, fully vaccinated means 2 doses of two of Pfizer and Moderna, or 1 of Johnson & Johnson, although I don't know about anybody taking Johnson & Johnson right now. It does not require the booster yet. I suspect so that's going to change. Everything, CDC has changed their requirements to fully boosted to include a booster shot, a 3rd shot, if it's been more than 6 months. There are exceptions to the first vaccine. So if you've got an employee who has had COVID in the last month or so, then they may have the natural immunities, and the rule does recognize that if you can get a doctor's note to provide that, then they're not eligible for the vaccine yet, then they can delay. The rule also recognizes the same medical issues that the OSHA rule recognized as a justification for a delay in getting the vaccine or an exemption, which is if you have a medical condition, like the most common one is allergies, I think. So if you have an allergy that might be triggered by a COVID vaccine, then you have a medical contraindication. I didn't know what that word was till about 2 months ago. If you have a medical contraindication to the vaccine, then you can get an exemption similar to the ADA. It's not a disability to have an allergy. It's just saying a doctor's going to say there's a risk that you may have a bad reaction to the vaccine. So until we know more, we're going to put you on pause, put you on a pause list. And then also, like I said, the ADA and Title VII religious accommodations. Those are the 4 ways you can avoid being vaccinated by the enforcement date of 60 days after, which basically is March 15th, by the way. So put March 14th, circle in red, and that's your D-Day. You need to have your policy in place before that. CMS wants to see 100% of your employees vaccinated or having received an accommodation. That's what CMS wants to see. Your clients, the CMS facilities that you're doing construction with, is likely going to request this documentation, right? Because when the state surveyor comes through and they ask for records of all persons who've been on site and they don't have your stuff, it's going to look bad for them and jeopardize their CMS funds. You can share this information. It is okay. Vaccination status has been deemed under the EEOC regulations to not be a medical examination. However, you do have to maintain it as a confidential record. So, don't post your vaccination list on any break room board or save it on the, intranet where anybody can access it. It needs to be under digital lock and key. If you share it with a client, or if a client requests that you share it with them, you may do that, and you're going to have to. Proof of vaccination. The rules also address what constitutes proof of vaccination. Typically, hands on the card is being asked for, or a doctor's note, or a letter authorizing an accommodation. Typically, photos do work. You can maintain this information in a secure database and then grant access to your CMS facility client so that they can access it anytime without delay. Or you can take old-fashioned paper files over there and drop them in their office, and then it's on them. And there needs to be destruction. There needs to be record retention and destruction rules in effect if you're going to do that, similar to other financial information, bidding information, things like that you want to keep confidential. There's some other nuances I can kind of go through. I just talked for about 28 minutes straight. I'm sorry. I want to take just a minute and open it up to any questions y'all have right now before I kind of give you my, Greg Northen's hot take on what you should be doing.
I have a quick question.
Yeah. Who's that, Corey?
Well, it's John. I'm on his link from
John.
CDI. So if you have somebody that brings in a doctor's note for, like, say, asthma or religious or one of the 4 that you mentioned, what do they automatically fall into the have to have a test every week? Does it specify those guidelines?
Great question. And so the testing every week is gone. The OSHA rule was what included the testing every week, or the Arkansas statute. So the OSHA rule, let me back up. If you're a CMS covered contractor, then the weekly testing is gone, because OSHA is what had that, and that rule is dead. Okay. As far as, pending a few final adjudications. The Arkansas statute requires the weekly testing for a private business's own vaccine mandate. So if you have a construction project and the project owner says, we're all getting vaccinated, I'm going to make you people get vaccinated to do business with me, that's fine. If it's in Arkansas, you're an Arkansas employer, Arkansas law, effective last Thursday, says you have to allow weekly testing as an alternative to getting the shot. CMS does not have the alternative testing. And it does not recognize it as an exemption. So if you have someone who gets a religious or a disability accommodation or has a doctor's note, as you indicated, and you grant their accommodation, meaning they don't have to get vaccinated because of whatever reasoning, then you as the employer, you can decide, you can require weekly testing. If you do at that point, though, you're going to have to pay for the test and you're going to have to pay for their time getting the test. You've now made it a term or condition of employment that is not required by law. And Arkansas has an older statute that says if you require any type of medical exam, including the COVID-19 test, then if you choose to require it, just like a background check or a medical exam, then you have to pay for it. If CMS is mandating it, we're saying, no, you don't. But CMS does not recognize alternative weekly testing. And if you remember earlier, I said, what's your CMS covered facility, right? Your client, the one who you're doing the construction work for, if they choose to allow unvaccinated workers through an accommodation or medical condition, whatever it is, if they choose to allow them on site pending a weekly negative test, or they could do a daily negative test. I mean, they can require whatever they want to require to not jeopardize losing their CMS funding. And if they do that, then you're going to have to either pay for that employee, or look, take your unvaccinated employee off that job and put a vaccinated employee on. You as the employers, this is getting into Greg's hot take. You all get to decide who works on which project and who doesn't. Now, I understand that there's kind of some seniority, and if you have a collective bargaining agreement, that's a whole nother matter. But if you're just a run-of-the-mill Arkansas business and you kind of got your crews and you don't want to break them up because of momentum and the way we've always done things, or even skill sets, I get that. But you can come up with what we've talked about doing, and this is very difficult, especially for the short term. I don't know how long this stuff's going to be around, fellas. I really don't. This could be 3 months. This could be 3 years. So if you want to, you can come up with pods. I don't know a better term. Crews. Crew A is vaccinated workers. Crew B is unvaccinated workers. And when you're bidding projects under CMS guidelines or other federal contracts that maybe, whether it's highway funds or, schools, those kind of things, if you might fall under another federal contract or vaccine mandate, then you can have, keep in mind, you can only bid within the constraints of the availability of Crew A to work those jobs. But a lot of it is also going to depend upon who your contracting entity is. So your CMS covered facility is going to have a lot of contracting authority over you in regards to these requirements. And so some may be more flexible than others. They're supposed to put a contract clause into your contract, right? CMS came out with a, standard compliance with Executive Order 14042, put it in the list of things, either your other terms, all your addendums or wherever it is. But, and this is where the legal wires are still kind of exposed. This rule but the way it was issued is kind of a law that you have to comply with, irrespective of whether there's a contract clause, but it's supposed to work as a contract flow down. You're a subcontractor to an agency receiving restricted federal funds. And so it's supposed to be a flow down, flow up, kind of like Davis-Bacon. So you should have a contract clause either asked to be amended into your existing agreements, or for future agreements, when you bid on them, the final contract should have a clause in there that states exactly what your compliance requires. I've heard mixed reviews from clients. Some have said their entity has issued a contract addendum for ongoing construction projects. I've heard many others who said, we've not received anything. Do we have to comply? Well, the CMS will in Arkansas, after 60 days, will likely start flagging CMS covered facilities who are not in compliance, even if there's not a contract clause. So they're most likely going to implement these enforcement requirements for you all who are doing work with them. Good question, John, not Corey. Any other questions? I know this is a lot. It's been around. We're all sick of it. If you're getting COVID fatigue on the compliance side, we've got jackets. Join us. It's a turbulent time, but I think we finally have some finality. The Supreme Court has finally spoken, and it looks like CMS is going forward. It looks like the Department of Ed's going forward. Head Starts has still kind of stayed. Other agencies are likely going to follow suit from CMS. So if you're a federal contractor, any hope that this is all goes away soon is setting quickly. It looks like it's going to be here. You need to have a policy in place next week. You need to have a roster of vaccinated workers this week. That can be done relatively quickly. If someone refuses to provide proof of vaccine of their own personal choice, then they have to be treated as unvaccinated. That's just the way the rules work. If you want to negotiate with your project owners or your prime contractors or generals or first tier subs, whoever it is, you can certainly try to do that. The CMS rules, the biggest thing is, are your workers going to come into contact with covered facility workers or patients? If you're adding an expansion to a new building that's 80 yards off of the main building, and there's nobody coming over there but your workers and other contractors who aren't CMS covered facilities, then your crew may not be required to be vaccinated. If they're going into the building and remodeling a wing and they're going to be in the hallways with other people, then they definitely most certainly have to be vaccinated, or they'll fall under the vaccine mandate. So this is not just a contract by contract. This is a job site by job site analysis. So you all have to determine, and you can talk with your, I guarantee you these CMS providers are going to be very nervous about any fluctuation from the vaccine mandate. They're going to want to ensure compliance because they don't want to jeopardize their money. But if you've got one who's fairly reasonable and you can say, look, our folks are going to be 160 yards away and we'll put a partition up or some type of yellow flagging tape or something, a do not cross barrier, where our folks are over there and y'all's are over there. This does not fall within the mandate of the vaccine by the rules. You've got some good arguments to make. I mean, I think that's legitimate, but you also don't want to jeopardize your contract for that work. So that's pretty much it. I'm going to wrap up if there's no other questions. I'll just tell you, like I said, your policy needs to be put into effect now. Your list of your roster of vaccinated, unvaccinated, keep it confidential, but have it on hand in case you ever, so you're not behind the ball. If you've got ongoing projects and you have unvaccinated workers, you need to decide now and give them time to seek an accommodation if they're going to seek an accommodation from getting the vaccine, or give them time to get the vaccine. Lines are pretty short for vaccines right now. They're not short for getting tested. But thank goodness we got away from that OSHA ETS testing rule. That was gonna be a real nightmare. This may change further. ABC's got information Bill will send out from ABC National. We got really good general counsel at the national level. I mean, it's almost as good as your state level, but either way, we'll make sure y'all stay apprised. There's a lot of stuff in the news. A lot of noise about this, but I'm thinking it's probably going to start quieting down, and we have direction now. So I'll take any final questions or let y'all get back to this glorious day. Just happy as can be. I answered all the questions. I knew it. This is what happens when I talk for 28 minutes straight. I just answer all the questions. Bill, Megan, do y'all want to close with anything? Appreciate y'all joining us today, and let me know if y'all have anything afterwards.
Yes, yes. Well, Greg, I wouldn't be shocked if you had one or a dozen emails in your inbox at some point later today with some follow-up questions. But no, I just appreciate you taking the time to keep us up to date. I'm sure we're not the only group you're trying to educate on all this as things progress. But no, and to the people on the call, just know if there are other updates that are significant, we'll keep everybody in the loop. If at some point we need to have another one of these Zoom check-ins, we absolutely will. That's kind of one of the benefits of having someone like Greg involved, is we hear it directly from the people that are trying to corral all the craziness. So Greg, I appreciate you. If there are no other questions on the call, we will go ahead and close out today, and I will have Bill blast out this recording once we get it cleaned up. But otherwise, appreciate you guys. Shoot me or Bill an email if you don't have Greg's contact info and have some questions, and we'll make sure it gets to him. Other than that, appreciate your time. Hope you guys have a great rest of your week. And,
Thanks, Greg.
And Bill says thank you as well. Thanks, guys.